September 2012, Muhammad Roziman bin Saaidon and Al-Muhaimin bin Muhammad Razi was arrested for taking methamphetamine and were brought to IPD Kulai Jaya for further investigation. Methamphetamine is a class of dangerous drugs under the Malaysian law, Section 15. On 18 October 2012, the examination and analysis of the urine samples of the applicants are conducted by the science officer. Months later, on 28 June 2013, the Court of Appeal held that urine specimen examination and analysis must be conducted by a medical officer, and that a science officer has no jurisdiction to do so. As on 25 July 2013, the prosecution applied to the Magistrate Court for an order to charge the applicants on discharge not amounting to acquittal, to which the court agreed. DNAA means the accused is let go for now, but the courts can still charge him on a later date. This might be due to the lack of evidence or incomplete investigation. On 15 February 2014, amendment to the Dangerous Drugs Act, Section 31A 1AA was established. This is the date of the new law. In September 2014, the applicants were recharged for the same offence under Section 15(1)A Dangerous Drugs Act 1952. The prosecution relied on the new amended Section 31A 1AA, which now allows the applicants' urine samples to be examined by a science officer. The issue of the case is whether the new amended Dangerous Drugs Act Section 31A 1AA is retrospective or prospective. The second issue is, can the applicants be recharged again?
Rule of law for Muhammad Roziman bin Saaidon vs. Public Prosecutor case, Article 7(1) of Federal Constitution, protection against retrospective criminal laws and repeated trials. No person shall be punished for an act or omission which was not punishable by law when it was done or made, and no person shall suffer greater punishment for an offence that was prescribed by Section 15(1)(1) DDA 1952, Section 15 Self-Administration. Any person who consumes, administers to himself or suffers any other person to Section 14 to administer to him any danger specified in Parts 111 and 4 of the Schedule should be guilty of an offence against the Act and shall be liable on conviction to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 2. Section 31(1)A before amendment, when any person is arrested on the charge of committing an offence against the Act 31(1)A for a purpose of preservation of evidence, it shall be lawful for a police officer not below the rank of sergeant or an officer of customs to require an arrested person to provide a specimen of his urine for the purpose of an examination under subsection 1, if it's not practicable for the medical officer or the person who is acting in aid of or the direction of a medical officer to obtain the specimen of the urine within a reasonable period. Section 31A 1AA after amendment, the Dangerous Drug Act or DDA 1952 Act 234, which is referred to as the principal act in this act, is amended in Section 31A by inserting after sub 1A for the following subsection. 1AA, any biological sample collected for the purposes of the examination under this section may be analysed by a science officer employed by the government.